house. There were not individuals outside of the house, but the house was shot. During the shooting of that house, Ms. Denise Bell, who is the aunt of Darren Mills, while she was in her bed, sustained a gunshot to her buttocks and had to go to the hospital and had to have surgery. She was shot. The house was shot up, and there were other individuals there at the time, including Cecilia Davis and Diamond Mills. Diamond Mills being Darren Mills' sister. Also, the car belonged to Cecilia Davis, which was in front of the house and received damage. The evidence is that Mr. Sledge was the driver of the car. After that, Mr. Sledge drove over to 1903 Drew Drive, Northwest, an apartment there was at the time being used by Philip Collins, who is Darren Mills' brother, and also present at the club and participated in the assault. In shooting at what they believed to be Philip Collins' apartment, they damaged apartments 1122 and 1120. Natasha, is that a blind plea or something else?
I think it was just a plea. It wasn't a blind plea, though, if I'm not mistaken.
For a regular plea, what do you understand to be the terms? In other words, do you know your sentence before you plead guilty with a regular plea?
I don't know, because before the blind plea, I knew my plea.
Why did you then distinguish for the jury that it was a blind plea?
It was, but I already knew the sentence. My lawyer had already aware to me that they was offering the same thing. They was offering the co-defendants what they had pleaded guilty before me.
Okay.
So when I pleaded guilty, my lawyer aware me that they was offering the same plea deal that they gave them. But in my plea deal, I told my attorney that, I didn't want the probation. I just take the straight prison sentence.
Okay. Yes, sir. All right, outside the presence of the jury? Okay. Yes? Yes. Okay. I'm going to excuse y'all to the jury room.
Your Honor, will the witness be excused?
Yes.
And Your Honor, may I first grab it?
To do what? Sure. Yes, sir.
Thank you, Your Honor. Your Honor, I have a motion. Prosecutor, I believe it was the Honorable Mr. Bailey, who entered this plea and gave a factual basis. But she did not make it clear that the Honorable Derek Wright said on page 12 of this transcript to the same court that Mr. Sledge is tendering the plea under Alford, which is ALFORD.
Yeah, I'm seeing the same thing. And honestly, I thought that we were going to be dealing with the guilty plea that he took in this case. And yeah, that's problematic that this 2015 case is an Alford plea. And so I don't think that any of what I said with regard to admissions is actually true, even against this. I mean, he's saying he pled under Alford, and I don't know why the Disposition sheet doesn't say that, but it is very clear that this is an Alford plea in this 2015 case. So Mr. Wright wants to share something.
Yeah,
Yes, sir.
I was just waiting for the appropriate time that I was going to point out that it was in fact an Alfred plea. So I thought her cross-examination was not appropriate.
Well, y'all, I mean, maybe that,
Suggesting
yeah,
it was something other than an Alfred. So
well, maybe don't wait so long next time.
yes, yes.
But I mean, I'm definitely going to, Ms. Lev, do you want to be heard?
Yes, please.
All right, go ahead.
One, we'd ask that the court deny the motion for mistrial. Number two, we would ask, as it relates to the assertion that no inconsistent statement was made, in the factual acknowledgments.
Okay, no, see, that's the deal with an Alfred plea, is you are not acknowledging that the facts are true like you would in a regular guilty plea. You're saying, I think that the state has enough evidence that a jury could be convinced beyond a reasonable doubt that these facts are true. But
Yeah.
you're not acknowledging on your own, yes, these are true.
Your Honor, when
Yes, ma'am.
I spoke of the factual acknowledgments, I meant 444Y.
Well, that's what I thought
Within-
you meant.
Within 444Y, we referenced this particular
All right, let's,
section.
maybe if you can point me specifically, let me pull that one up.
Page
Which number? Go ahead.
number 3 on page 3 of 7, under defendant's factual, I'm sorry, not number 3, number 4, on defendant's factual acknowledgments, on or about April 28, 2015, as reflected in Fulton County Indictment 15 SC 138994, defendant and fellow YSL associates Demekion Garlington and Quindarius Zachary committed a drive-by shooting using the firearm defendant wielded in the video referenced in Part 3 of this section, targeting family members of a rival gang. Number 5, defendant and his fellow YSL associates committed the drive-by shooting referenced in sections 3 and 4 above on behalf of YSL and to increase the notoriety, reputation, and fear of YSL.
Okay, and so those factual assertions, what I read as the limiting instruction would be true for.
And
But the factual basis that you just read out from the 2015 one, that's a whole lot more than what's in numbers 4 and 5.
Your Honor, in number 6, defendant admitted committing and was convicted of aggravated assault and participation in criminal street gang activity, among other charges, for his participation in the drive-by shooting referenced in section 3, 4, and 5 above.
Okay.
And so if I'll, of course, comply with whatever appropriate instruction that the court deems necessary to give as it relates to the conviction of this witness for 15 SC 138994, but given the factual acknowledgments that were made as it relates to 22 SC 183572, and the fact that this witness did not assert, even though the plea was given in his best interest, he was allowed an opportunity to say what he said here, and he did not say it.
No. When a defendant has an attorney who is saying, we are pleading this because we believe it to be in his best interest, the defendant does not then independently need to say, yeah, by the way, judge, here's what Alfred means. So
Understood.
no. Are you going to tender for admission any part of 444Y?
Yes, the state intended to tender 444Y.
In its entirety?
Yes, I
Okay.
did.
Any objection to that being tendered in its, or admitted in its entirety?
And if there is an objection to it, then
All right,
we would just.
let's find that out.
Okay.
I just don't, yes, I object at this point to the entirety of the document unless the state can give reasons for which parts of the document are admissible at this time. And if they're not tendering yet, I understand that. But I can't get around how we got here. You know, I'm trying to follow this factual basis, and I realize I asked Ms. Renard, R-E-N-A-R-D, for this, and we're in a different case.
Yeah, we are. So, we've been talking about these 2015 crimes, and we've been talking about, what's been going on in this 22 indictment. So, I guess that's how it came about. But I wish we'd been a little more specific about it all beforehand, because, I noticed this morning that this was an Alford plea. And I would have had issues with, when you started reading out the factual basis, I'm thinking, well, is this some other case that I don't know about that's not the 2015 case and not the 22 case? Because we should have been reading the factual basis from the 2015 case.
Your Honor, the 2015 case, I understand what the court is saying. The 2015 case is one of the overt acts that we allege in the indictment. And as it relates to the defendant's conviction for the 2015 case, we believe that it would be appropriate is an appropriate matter for cross-examination, and it appropriately falls under the portion of the court's instruction where it tells the jury that the conviction itself is not to be considered as evidence. And to the extent that Mr. Sledge is asserting that he didn't do it, that he dropped someone off, that is what he asserted, by the way. He said that he was not present. He dropped him off, and it was only one house.
Well, we all know how party to a crime works. So, yeah, he said, I didn't shoot, but he did admit to being the driver.
And so, to the extent that he said that, the statement contained in his factual acknowledgement that he and fellow YSL associates, and I'd also point out that early on he made a very blatant, inconsistent statement that YSL is not a gang. And in this factual acknowledgement section,
All right, we're not going to use anything in the factual acknowledgement section of the 2015 plea.
no, in the 22 SC 183.
Okay, yeah, no. All of that is inconsistent with any of his trial testimony is fair game for you to tender for admission and for them to consider as substantive evidence against everybody. The issue we have that needs to get cleared up is that before I read this limiting instruction, I thought you were going to tender the guilty plea to this 22 SC case. And it turns out that you were talking about the 2015 case, which I understand you're saying we did part of that as, part of the 22 factual acknowledgements. So those factual acknowledgements in there are fine as well. When I say in there, I mean in this 22 case. But I'm going to have to clarify for the jury that what I told them about prior inconsistent statements
does not apply.
And that everything you just read from that guilty plea also needs to be disregarded.
So, Your Honor, as it relates to the court's instruction to the jury regarding the inconsistent statement not applying, we would only ask that the court specify that the court is speaking as to the factual basis that I asked the witness about in 15 SC 138994, particularly where he has testified and he pled in his best interest.
Okay. And you haven't tendered yet the 444Y. And so at the point in time when you tender that, then I'll say, okay, for this one, this
Okay.
is true.
I see what, yes,
Okay.
yes.
All right. If anybody wants to suggest specific language, I'm willing to listen. Otherwise, I'm just going to kind of
And,
give it my best shot.
I would
and
like,
Your Honor, may I say one more thing?
Yeah.
Because number one, the court has previously instructed the jury that questions, and I understand the content of the question needs to be addressed. But given that the witness has testified that he pled guilty in his best interest, and given that he can also be cross-examined as to whether or not he was asserting these things, we don't believe that anything beyond a instruction regarding the factual basis for 15 SC 138994 not being considered a statement of the witness is required.
Okay.
I just respectfully don't think that goes far enough. You have a prosecutor who's saying it's just a blind plea. She leaves out everything about Alford. She elicits, and I'm not saying that she could have anticipated this, but her questioning elicits that a non-testifying severed co-indictee pled guilty also. That is a total Confrontation Clause violation. It's the second time.
All right. And that's Zachary and.
Well, Mr. Zachary, I anticipate may testify.
Right.
I don't know. He hasn't yet, but it definitely includes Mr. Garlington, who the state has said will not be testifying. And then, just for you to know, you were not here, but the predecessor judge permitted, over objection, the state to do the same thing. They did it with a Mr. Winfrey, just like the court reporter's last name. He's not going to testify. No one believes he's going to testify. The state doesn't say he's going to testify. And they got out that he pled guilty. So they're aware of all this. And in fact, the state elicited in that case that the gentleman, Mr. Winfrey, pled guilty to avoid plea. It was vacated by the Supreme Court of Georgia.
Yeah, I remember you.
So, and
Didn't
then
he enter another one after the fact, though, anyway?
5 years later, Alford plea and said I'm
Okay.
specifically innocent.
Yep.
I mean, it was a farce.
Right.
And
Okay.
and then the predecessor judge wouldn't even let me examine the witness. And Miss Love said that the witness I could call in my case in chief on direct. So the reason I'm bringing that up is this is not new.
Okay. What's your intention with regard to Mr. Garlington? Do you have any intention of calling him?
Your Honor, no. And Mr. Steele is absolutely correct in terms of the witness testifying about Mr. Garlington and Mr. Zachary and his doing that. There's nothing that indicates that the only reason he did that was because they pled guilty. So that is not, in other words, his statements that he gave to the jury about Mr. Garlington pleading guilty and all of that are not something that I asked him about or expected him to be talking about.
Right. Okay. But nonetheless, we have that now before the jury.
We would
So-
ask that the court tell the jury to strike, disregard, put out of their mind anything about the Mr. Garlington pleading guilty.
I'm just to say anyone other than the witness on the stand.
Okay.
Your Honor, if I could be heard.
But Mr. Zachary is a witness.
I know that, but he hadn't been called yet, has he?
No.
So
no.
deal with it when he gets called.
Yes.
Yes, sir.
Your Honor, on behalf of Mr. Sledge, clearly at a jury trial, we are always assessing the credibility of witnesses. My client has now been impugned, or at least attempted to be impugned by the state by suggesting that either he should have been making a statement or his plea was something other, or that these facts are in fact his adopted, admitted facts.
I'm going to make it clear that that's not the case.
And that's where I want to make absolutely clear that he was right in the position he was taking, that it was in his best interest.
All right. Anything else before we get the jury back in?
Let's run to the bathroom.
That is a great idea. Let's all do that. Or take that opportunity. Okay, that is denied.
And then, because you're giving curative instructions, maybe instead of making the same motion to review it before the next question, can you just acknowledge that I would have done that and then still do the motion for mistrust?
Yes. All right, let's take 5 or 10 minutes ourselves.